Hello, everyone. We're just gonna wait 1 or 2 minutes for more people to join in, and we can start this webinar. Hey, I think we're gonna kick off now. Thank you everyone for joining. Good morning or good afternoon, good evening, depending on where you are. And welcome to the Smith School of Enterprise and the Environment's webinar on navigating climate-related legal risks and opportunities. My name is Giovanni Palafox Alcanta. I'm the head of executive education and a former research associate in sustainable cooling systems here at the Smith School. At the Oxford Smith School, our aim is to bring public and private enterprise together with world-leading research to achieve global net zero emissions and sustainable development. Our approach combines academic excellence with a deep understanding of real-world impact. Through solutions-focused research and teaching, and by bringing enterprise into the conversation, we can build this cleaner, fairer, and more prosperous future. Our executive education programs empower leaders and policymakers to take action. And today, I'm very delighted to be joined by Thom Wetzer and Benjamin Franta, both leading experts in climate change law. Thom is the founding director of the Sustainable Law Program at the Smith School, an associate professor of law and finance here at the University of Oxford. And Ben is a senior research fellow in climate litigation at the Oxford Sustainable Law Program, again at the Smith School. And he's also the founding head of the Climate Litigation Lab. So it's a pleasure to be here with you today, Thom and Ben, and really looking forward to hearing more about climate policy litigation and climate science. And I'll hand over to you to learn more.
Thank you so much, Giovanni, and thanks everyone for joining us. We just want to give you a closer look at this course we're putting on in June about climate-related legal risks and opportunities. We're covering a range of topics, and we want to give you a sneak peek of what those are. So here's the program. Each day is themed with a different aspect of climate-related law. We're going to talk about the overall challenge of climate change and climate governance in the first day. Why does climate change impact the law, and how does it impact the law? What's the scientific overview of decarbonization and the need to decarbonize and net zero policies happening right now? What about international climate change law and the UNFCCC process? How can we understand that, and how can we use that understanding to help us plan for future policy developments? And we'll also talk about the politics of climate change. What are some of the forces that are influencing whether certain policies are enacted or not, and how might an understanding of that help us plan as well? Now, each day we're going to have intensive, content-rich sessions throughout the day, and then in the evening, something a little lighter. So Oxford, as you probably know, is a beautiful place. It's historic and lots of interesting things to do. So each evening we'll have sort of a fun and interesting activity, enriching activity. First day we'll be doing a walking tour of Oxford, for example. Day two, we'll be focusing on decarbonization. We know that decarbonization and the energy transition is something that must happen to solve the climate problem. More and more urgency is being put on that goal, and the law is being activated for decarbonization. So we're going to talk about different strategies to decarbonize, the science, of reducing emissions. And we'll also talk about carbon dioxide removal, which is a hot topic, and what role that might play in decarbonization. We're going to have various discussion sessions as well, not just lectures. So this whole course is designed to be interactive, to have you as a participant be a key part of the experience. And we're going to have various discussions, including panel discussions that are interactive about these issues as well. Finally, that day, we're going to talk about what are the different net zero policies that are being implemented and looked at today, and that's going to shape the whole regulatory environment for climate going forward. And we're going to take a sneak peek at litigation. How is litigation being used to force and compel decarbonization, both by corporates and by governments? And this is a key emerging area to understand that presents a lot of risks to some sectors and some opportunities as well. And then that evening we'll have a nice walk in the countryside near Oxford to a very traditional pub which has very nice food. So this is the whole integrated experience. Day 3, we're going to talk about climate impacts and accountability for climate impacts. This is a trend we've been seeing over the last 5 or 6 years. What do you do when you have climate damages manifest? These economic damages and even disaster-related damages can be very large, as are adaptation costs, and who pays for that? And how is that burden distributed? It's a very important issue to understand, both for sectors that are directly related to climate change, but other sectors that may be indirectly exposed to climate risk, like investors. So we'll talk about what's the science that undergirds our ability to attribute a climate impact to climate change and ultimately to greenhouse gas emissions. What are the economics of climate change impacts? How much does it actually cost? And how can we use that as a starting point to think about how that's going to impact different industries and sectors? We'll talk more about climate litigation because this is one of the key mechanisms we're seeing for attempting to force certain parties to pay for these impacts, like fossil fuel producers. And then we're going to have a very interesting debate about climate accountability at the Oxford Divinity School, which is one of the most beautiful spaces at Oxford, and that should be a very fun and enriching, interactive activity for all of us. That evening will be punting, which is a traditional Oxford activity of kind of standing up in a boat and pushing it along with a pole. You'll see more what it's like when you do it. It's very fun. It's a traditional pastime in Oxford and on the river in Oxford. Day 4, we're going to take everything we've learned and talk about climate governance and accountability, combining that. How do we govern this whole system? Decarbonization, climate impacts, and so on. So we'll talk about finance, what are the perspectives from the private sector, from government, and from NGOs, because all of these groups are interacting in this space, sometimes in antagonistic ways, sometimes in cooperative ways. And there will be attendees from all of these sectors. So that's another aspect of this course we want to bring value through, is to bring all of these groups together to learn from each other. And we'll be doing a formal dinner at one of the colleges at Oxford that night, Keble College in Oxford. And finally, day 5 is our wrap-up and synthesis day. We're going to be reviewing and kind of bringing together everything we've talked about, having a lot of space and time for you to work with each other and identify what are the action items and the key points that are coming to the top for you, so that you have something actionable and not just a theoretical insight, but a practical insight that you can take back with you to wherever you work or whatever sector you're in. So that's an overview of the content of the course. Again, our goal is to provide a lot of value. It's intensive, it's 5 days, and each day has a lot of content. And so we want to bring a lot of value to to you wherever you work. Part of this is the teaching staff. So we have a great teaching staff, some of whom are shown here, of world-leading experts in their areas, like Professor Lavanya Rajamani, who's an expert in international climate law. We have attribution scientists like Rupert Stewart-Smith. He's Dr. Rupert Stewart-Smith. He's one of the leading climate attribution scientists in the world. Professor Thom from the Blavatnik School of Government, a professor of political science, and of course, Thom and I and others as well. So we have a great lineup of instructors as well as practitioner guests as well from various sectors who can share their insights about how do all of these issues affect their practice. And then this is also about the Oxford experience. You know, this is not just something that like you might experience over Zoom. This is an in-person experience. So we want to really bring you the Oxford experience. You'll be living and in the colleges. You'll be taking these courses and sessions in college facilities, dining in the colleges, and so on. Oh, I mentioned the punting. Yeah, just experiencing the whole community environment of Oxford is very special. We're going to be having the debate in the Oxford Divinity School, which scenes from Harry Potter were filmed. It's just absolutely beautiful. And of course, dining in these historic spaces as well. So that's a broad overview, but we want to give you something a little more substantive as well. And so we're going to talk about three cross-cutting themes in this course: policy, litigation, and science. And really, these are three cross-cutting themes that they cut across the entire course. So Thom is gonna give us an overview of some of the key ideas from the corporate climate action and the net zero policy space. Off to you, Thom.
Great, thank you so much, Ben, and welcome to everyone who's attending. It's really great to see so many people interested in the course. So this sense of cross-cutting themes is really important because we believe that in order to really understand this rapidly evolving legal landscape, you do not only have to bring together different perspectives from the law and from other disciplines like economics and physics, but you also really need to make sure that you have that sense of how all these different actors and their activities interact. So these cross-cutting themes, as Ben already mentioned, they'll be prevalent throughout the course. And the first one I want to give you a teaser of is that related to corporate climate action. So there will be no surprise for most people on this call that corporate actors are key players in economies around the world, not just because of the GDP size that they represent, but also because of their innovative capacity, and in some cases, for their capacity to be an obstacle to change. So they can be agents for change, they can be obstacles for change. And that means that they play a critically important role in the transition towards net zero. And more importantly, perhaps for our purposes, they also face quite a few of the dilemmas that actors who are operating in a rapidly transitioning environment are being faced with. So one thing that really characterizes the framework within which corporations operate in most countries, in most jurisdictions around the world, is actually a lack of requirements, a dearth of requirements when it comes to decarbonization efforts. So corporate actors, that means their boards, the shareholders, their advisors, they have a lot of discretion in terms of what direction they're going to go in. So questions that then arise quite quickly in the context of a net zero transition are questions like, will shareholders push for decarbonization? And if so, under what circumstances might they do so? And can firms credibly commit to reduce their emissions? We know that many firms have been making commitments of this kind, but are these commitments credible? And how do we understand credibility? And on the next slide, you'll see a few examples of cases that we will be discussing. So you see an increasingly sophisticated environment of corporate climate action with shareholders, sometimes organized in groups like Engine Number One, pushing for change, pushing big corporates, including corporates that have large fossil fuel activities, to decarbonize their activity. And on the right-hand side, you see another example of sophisticated corporate climate action, this time taken by the board. This is Energy, is a utility company in the US, and they issued a sustainability-linked bond. And these kinds of bonds are important because they basically create KPIs, for example, a decarbonization target. And if the company actually meets those targets, then the interest rate that they have to pay to the people they're lending from will stay low. But if they don't meet the KPIs, then the interest rates go up. And so this is a commitment mechanism that corporates can introduce in order to say and to signal credibly to investors, to consumers, and to regulators, we are heading on a decarbonization pathway. And we're committing, because if we do not meet these targets, we will have to pay up. And so questions that arise in this context are, is this really a credible commitment mechanism? How do we know that? And that's another set of questions that we will study. And on the next slide, you'll see why it's so important that we study these questions, because we know that corporations that commit to reduce their emissions frequently backtrack on those emissions when circumstances change. And we'll discuss to what extent that is to be expected, to what extent, in fact, that may be desirable, but we'll also discuss the obvious problems around corporations making commitments around decarbonization, and then when circumstances change, backtracking on those commitments. They're both pros and there are cons. There are degrees to which shareholders and a board could and should be held accountable, and there are perhaps also expectations on firms that may not be realistic for them to meet. So we'll discuss and unpack that complex environment to give us a better understanding of what corporates and the various stakeholders associated with them can do in the context of climate change. If we then move to the next topic, this is a topic that is very closely related. And it's a topic around the hardening of climate rules. So I mentioned just now that corporations tend to operate in an environment that is characterized by the absence of requirements to reduce their emissions. And what we see increasingly is that there's a ceiling to what we can expect corporations to do voluntarily, as we have just discussed. They, in many cases, feel forced to backtrack on commitments they've entered into previously. However, we should not immediately dismiss these kinds of voluntary initiatives as being unhelpful, because what we see increasingly is that there's a hardening of climate rules. That means that out of voluntary standards, hard rules emerge. We move from what we might call a groundswell of voluntary decarbonization to an environment that is increasingly characterized by having firm ground rules across the economy. And if we go to the next slide, then you'll see what we mean here. So what this slide shows you is with the yellow line, an increase in voluntary corporate climate commitments. And we see a very, very rapid increase since 2019. But the green line reflects the quality of those commitments. And the quality of those commitments, the depth, the credibility, that has effectively flatlined. So what that tells you is that although we see more and more corporate climate action, we also see that there's a ceiling in terms of what that action can achieve. And if we then think about how policy responds to that, which is what this slide shows you, is that many voluntary initiatives that corporations reach, including around issues such as what kind of information they share or disclose to their investors, that those kinds of initiatives start out on a voluntary basis, for example, through the CDP in the case of disclosure policy, but then through a process that we call a conveyor belt, they move into the hard rules sphere. So there's a movement, in other words, a political economy dynamic that allows parties, and these parties are coalitions of firms and governments and NGOs, to build on voluntary initiatives and then translate them into effective legislation. And we'll talk about how that has happened in the context of disclosure policy, but more importantly, as we'll see on the next slide, we'll also talk about how this continues to happen across many policy domains around the world. And that is a really important takeaway message that we will discuss, which is, as if we step back and we look at the governance of climate change and we look at the governance of decarbonization efforts, they frequently build, we frequently build on initiatives that start out as voluntary and then move into the rules-based sphere. And if we think about where we stand now on this journey, then in many countries around the world, we have reached the limits of voluntary action, and we're building now on that voluntary action to start to adopt hard rules. And that sets the scene for really rapid change in the regulatory environment. And the figures on this slide really illustrate that. So you can see here that across 5 key policy areas, there has been a rapid uptake in regulatory activity across G20 countries. We're now studying whether that uptake has also been present in countries in the global south, and so far the answer is in the affirmative. So that sets the stage for a disruptive regulatory environment in the years to come. And of course, that creates risks as well as opportunities, and we will on this course discuss how you can best prepare for those. Ben, I think over to you.
Thanks so much, Thom. So the next cross-cutting theme we want to dive into is climate litigation. And this is an emerging area. Of course, climate lawsuits have been occurring for decades, but in the last 5 or 6 years, we've seen a new kind of wave of lawsuits targeting corporates, but also stronger lawsuits targeting governments and their decarbonization policies. So this is a really key area to understand if you want to understand the sorts of risks that are posed by this litigation to various sectors and what kind of opportunities might also be brought by that. And that's, that's the two sides of the coin. So we have these lawsuits, and we want to understand what's the magnitude of the risk posed to various industries and sectors, and what's the distribution of those risks from these lawsuits. And also, what are the opportunities? If these lawsuits disrupt entire industries, if they disrupt current practices like advertising practices around climate change and sustainability, then what sort of new opportunities in the market, investment opportunities, or policy openings might be made available from this litigation? So we're going to talk about the trends, what's going on, what's the overview of climate litigation around the world today. We're going to take a global view of litigation. We're also going to take deep dives into what's happening in different countries. This is just a map of the US and the current climate damages lawsuits occurring in the US, much like the tobacco litigation or the opioids litigation more recently. And it's not unreasonable to think that there are hundreds of billions or even trillions of dollars at stake in this litigation. So this is going to have profound consequences for those targeted industries. We'll talk about some case studies. What do these cases actually look like? For these damages and greenwashing lawsuits, what are they based on? What's the evidentiary basis? What are the remedies that are being sought? So that we can take a forward look and understand how, whether you're in government or nonprofit sector or the private sector, how might these affect you and how might you prepare for them? We'll also talk about the decarbonization-based lawsuits, and these seek decarbonization along the lines of the Paris Agreement as a matter of law. And of course, this would have profound implications for sectors and government policy all around the world. So these are also very important cases to watch, and we've seen a lot of action from these cases and in the human rights space, which dovetails with this very recently. And we'll talk about future directions. We want to know what is going to happen. How can we be one step ahead, so to speak, regardless of what sector you're in? How can you prepare for what's to come? For example, these climate damages suits, if there are trillions of dollars or euros or pounds at stake globally, then what are the implications for markets for that and industries? For the greenwashing cases, we've seen a wave of greenwashing cases based on allegedly misleading advertisements around climate change, including offsets and things like that. Will this wave continue to grow, and will it mature and change in certain ways? And are there certain kinds of communications that may be targeted next that you might need to be prepared for? And then finally, these decarbonization suits, of course, the big question is, could the Paris Agreement become legally binding through these lawsuits in various countries around the world? And that will have huge implications for government policy and the entire economies of those countries and other countries as well around the world. So those are some of the future directions we'll take a look at. And again, one of our goals is to give you the latest information so that you can be at the very cutting edge of understanding these fields. I'll pass back to Thom for science and the law.
Great. So Ben already mentioned that one of the key issues driving change in the legal sphere are developments outside the legal sphere from the scientific perspective. And what we just want to illustrate is how we will cover issues like these on the course. So on the next slide, you'll see sort of an overview of how we think about these questions. So effectively, many of the climate cases have historically been limited by the limited availability of scientific evidence to substantiate the claims that were made. But over the past decade or so, scientific development in these spheres has accelerated to the point where now many evidentiary statements, many causal statements, for example, that underpin climate litigation can now be supported by very rigorous science. And that is really a perspective that we want to bring into this course, because what it suggests is that you cannot understand future directions in climate policy and climate science and climate litigation without also having an appreciation for how the science is developing and what kind of claims can and cannot be made with confidence on the back of that science. So we'll talk about issues like causation. Do a firm's emissions contribute to the damages that people incur? It's a factual question, but it's a factual question that informs the legal judgment around, for example, damages claims. And on this slide, you'll see on the right-hand side, a Peruvian farmer who has filed a litigation, a lawsuit against a German energy company, claiming that the German energy company's emissions have contributed to melting glaciers and the associated risks thereof in Peru. And that is the kind of causal claim that would have been impossible to substantiate even 10 years ago. But today it is possible, and it's possible thanks to the research of people working on attribution science, people like Rupert Stewart-Smith, who'll be talking about this topic on the course. And that has dramatic legal implications, and we'll explore those implications on the course. There are also scientific issues that inform questions around technical credibility. So someone in the Q&A already asked about voluntary carbon markets. Other people have asked questions about carbon dioxide removal. All of these new techniques and these new markets are rooted in technological and scientific developments. And so part of our understanding around the credibility of these climate solutions is rooted in an understanding of the climate science. And so if we want to make a legal judgment around reliance on carbon dioxide removal or around the credibility of voluntary carbon markets, we'll also need to understand the science behind these initiatives. And so that's the kind of perspective that this course will offer. And just to illustrate what that might look like in practice, on the next slide, we have some examples of the kind of science that we'll be discussing. So at the top, you'll see a model of glacial melting. And the model is used to assess causal claims around the link between man-made emissions and glacial melting, in this case, in the Peruvian Andes, in the context of the case of the Peruvian farmer who you saw on the previous slide. And these kinds of causal claims are very difficult to make, but they're not impossible to make. And in fact, from a scientific perspective, the causal claims become increasingly rigorous, as I mentioned. But it's an open question what that means for legal liability. So we'll discuss both the science and the law to give you a sense of those developments. At the bottom part of this slide, you see another set of questions that are normative and legal in nature, but also scientific. So here what you can see is that there are different emission pathways, different emission reduction pathways that we can follow. We can reduce our emissions very rapidly. We can reduce our emissions more slowly. We can have pathways that allow some countries, for example, countries in the global south, to emit more, and other countries, like the countries in the global north, to emit less. And these are, of course, normative questions, but they're also scientific questions, because the scientific questions and the scientific evidence sheds light on what is possible within a given carbon budget. And it also sheds light on what happens when we exceed our carbon budget. And so what that means is that an understanding of the science in this area will help us to inform better our normative judgments, and by implication, our legal judgment. And that can in turn have an important set of implications for how we look at international agreements in the context of climate change, how we look at government policy and how we evaluate government policy, and also how we might potentially, if we think not enough is happening, be able to hold these kinds of parties to account when action appears to be insufficient. So these are some examples of scientific questions that really closely interface with the law. And again, these are the kinds of questions that on this course we will dive into much, much more. Ben, over to you.
Thank you so much. So that concludes our description of the course. I think we have some time for questions, Q&A if you're wondering about topics or substance, or just logistics or timeline or anything like that. That's what we're here for I think the next 10 minutes or so we have time for that. So perhaps Giovanni, would you like to MC this section?
Absolutely. Yes, thank you very much, both Ben and Thom. It's been great to hear more about the course. We've had a lot of questions. Some of them have been answered, but so I just wanted to give you the opportunity to kind of expand on some of them in the chat. I'll just pick one there. And for example, somebody asked, Pavi Jain asked, will we be discussing carbon credits, voluntary carbon markets, and the regime? I don't know if you want to take a stab at that.
Sure, I can start, from a litigation perspective. Yes, we're going to talk about emerging areas of litigation, and carbon offsets is one of those areas. We've already seen some lawsuits based on the use of carbon offsets, in particular the misleading promotion of carbon offsets, of what they actually are, what they do, the over counting of offsets as well. And so that'll be absolutely something that we talk about, because it's a key area that's emerging. And there's also some new regulations and policies related to offsets emerging. And Thom, do you have anything to say about that? Because I think that's also a really interesting emerging area.
Yeah, thank you, Ben. And I already mentioned as part of the presentation just now that there are limits to voluntary activity, and there are limits to the credibility of that activity. And carbon markets are a really good example to illustrate that trend, because many of the governance mechanisms around voluntary carbon markets have arisen from industry bodies, have arisen from industry practice. And that has been incredibly important to the development of those markets. But it has simultaneously meant that there are some issues around the credibility of the governance mechanisms in this market that have remained unresolved. And interestingly, more and more governments are stepping in to regulate this space. But then the question is, do governments really take the kinds of actions that increase the credibility of these markets, or are they focusing on the wrong questions? And that's the kind of debate that we will also be having when we talk about voluntary carbon markets. And of course, all these perspectives, litigation, government activity, voluntary action, and the incentives of all the various parties involved, these all interrelate. And so we will be covering those questions. It's a wonderful case study to illustrate how the different perspectives we cover on this course should be seen in an integrated way. So we'll be covering those questions for sure.
Great, absolutely. I think even more questions have popped into the chat now. So I'll think I'll pick a different one, which is on are we including how corporate laws have defined director duties and corporate objectives that may have impacts on issues such as decarbonization?
We will absolutely do that. So as I said before, corporates are in a pretty difficult spot, and their advisors are in a pretty difficult spot, because people know that in general, if we abstract away and if we just look at the corporate sector in most countries, we know they have to decarbonize. But there are no rules forcing corporate parties in most jurisdictions to decarbonize. And there is a very strong incentive coming from shareholders, coming from other parties, for these corporates to remain economically competitive. And one of the tragedies of climate change is that in order to become economically competitive or to remain economically competitive, very frequently it pays to keep polluting the environment. And so there's a trade-off, at least in some cases, that directors will have to make between remaining profitable or in a traditional sense and switching their activities. Now, it is important, first of all, for directors to appreciate when this trade-off is not a trade-off. So in some cases, you can decarbonize and be more profitable. And so that is a judgment that directors will need to make. But where there is a trade-off, or where there is a perceived trade-off, at least on the part of some corporate constituencies, then the director's duties become really important. Because let's say that a board decides not to pursue decarbonization activity, then directors' duties may be invoked to force them to change their mind. And on the flip side, if a corporation and its board decide to decarbonize rapidly, then that strategy may also be challenged on the grounds of directors' duty. So it's really important that we discuss the position that directors are in, the options that they have at their disposal, and that is exactly the kind of topic that we will discuss when we talk about voluntary action and the role of the corporation in that sphere.
Great, thank you, Thom. I'll just move on to a slightly of a technical question. So people have asked if we'll incorporate the Global South perspectives. I think you've already answered yes, definitely we'll do that. And I think one of the objectives of granting the scholarships that we're offering is to bring people from developing countries, from low and middle income countries. So yes, and in regards to the scholarship applications, yes, we'll be in touch by the end of the month with decisions. Now going back, there's also a question around will we also consider emissions attributions methods under the law and accounting methods for scopes of emissions, and also talking about the possibility of mandating measures such as carbon offsets, particularly for hard to abate sectors.
Yes, absolutely. I mean, those are some key issues related to policy and litigation as well. You know, from a litigation point of view, understanding scopes 1, 2, and 3 and how they fit into the legal system is really key. In the Royal Dutch Shell case that's ongoing right now, that's one of the big issues that's being argued about, is whether to include scope 3 emissions, for example, in that legal judgment. And so there's a big question of how far and how expansive these legal judgments will be. So that's going to be something we'll look at. We'll look at carbon accounting so that we have an understanding of, you know, what are the corporate entities, for example, that are implicated in these sorts of legal actions, and so on. So yes, absolutely. And Thom, do you have anything else to add to that?
No, I mean, I think it is important to say this is not an accounting course. So there are some technical accounting questions around emission attribution that we will not be able to go into, but we will be able to go into the legal questions that arise from these accounting methodologies. And Ben already gave some highlights. So should we include scope 3 emissions in corporate emission reduction pledges or as part of transition plans? And how would we do that? And similarly, how should we think about serviced or financed emissions? And should we equate them with scope 3 emissions from a legal perspective? And in that by that same token, make corporates and their emission reduction planning cover those serviced emissions and those financed emissions? And these are very pertinent legal questions, because as we speak, litigation is happening on exactly these issues, and government bodies that are looking at transition plan legislation are also thinking about whether that kind of legislation should include scope 3 emissions, serviced emissions, and financed emissions. So from that perspective, we'll surely cover these issues.
And just to add, that it's a really great question because it's very rich. And I think part of the question was about remedies, things like, what about mandated use of offsets or something like that? And, that is a key question, especially for litigation. What kinds of remedies are being requested for a decarbonization case? What can the defendant do if they're required to decarbonize? Can they use offsets to meet that obligation while other companies are being sued for using offsets, like Delta Airlines and KLM are being sued currently for offsets? So, we'll get into that, because remedies is really kind of where the rubber hits the road, so to speak. And so we want to understand what will actually happen on the ground with these legal actions.
That's great. I think we still have quite a few questions in the chat, but we're running out of time. So I think what we can do is collate all those questions and perhaps circulate our responses with the recording. So I think it might be time to wrap up, as we only have 1 more minute. I want to thank you, everyone, for joining us today. We really hope that this webinar has provided valuable insights into the critical issues surrounding climate change law. And just to remind you again, for more information about the new course, please visit the link provided in the chat or on our website. There will be a recording that will be available, and we will share it with our mailing list shortly, along with the questions that we didn't have time to answer. So thank you again, Ben. Thank you, Thom, for your expertise, for your time. And thank you to all the participants for attending today and those who will watch this recording later. We are very much looking forward to continue these exciting conversations at the end of June this year, 2024, at this course called Navigating Climate-Related Risks and Opportunities, in person here in Oxford. Thank you, everyone.
Thanks, everyone.
Thank you.